without any further ado, my name is Scott Marcus, and this is our 5th masterclass webinar. I'm joined by my law partner, Elana Polashuk.
No, can't believe it's been 5 already.
Yeah, we're on 5. And we've got our special guest, Bill Worrall, who is kind enough to join us. He's on the Jersey Shore right now. And a little bit about Bill. He's a native of Maryland, born and raised just south of Annapolis. His father was a NASA engineer. So Bill's got pretty intelligent genetics. Bill is graduated from the University of Maryland with an economics degree. And he spent 18 years with FirstService Residential, which is an association management company. And ergo, the reason that Bill is our guest today, we're going to be speaking about associations. And mostly, you know, we could spend hours and hours on particular statutory, particular chapter and verse of statutes. But this is broader for real estate agents, and this is more of a understanding best practices, how to or what not to do. So with no further ado, Bill, welcome, and thank you for being here. Tell us a little bit about FirstService Residential.
Excellent. And Scott, and the entire firm of Becker, we've loved working with you guys for many, many years. So Scott, Elana, thank you so much for having me today. And it's a pleasure to be here. It's very exciting to have this conversation. At FirstService Residential, we're the North America's largest, that's US and Canada, largest property management organization. We're so proud and humbled to serve over 7,000 communities today, which represents over 2 million residential units. And we're also the only ones in this business that are publicly traded. So everything is with us is an open book, high levels of accountability, transparency, everything that's required that comes along with that. And I know here in Florida, which is where I do most of my work these days, we've been in business now for over 31 years. So very excited to be here today. I've worked in my career across distressed real estate assets, condominium associations and luxury high rises, all the way through garden style condominium associations and lower density HOA communities as well. So it's just very exciting to join the conversation today and to support. And I hope everyone can take 1 or 2 things away that'll help them out.
Excellent. Yeah, that's the key is, you know, if we can impart a little bit of knowledge on the listening community, that's the goal. You know, in my practice as an attorney, Bill, and Elana has seen it, I will frequently get a inquiry or a statement from a real estate agent. Hey, my client is buying a property and it's a condominium. And that may, in some cases, be true, but in other cases, it's not necessarily a condominium, it's a homeowners association. And we just want to make clear to the listening public that those condominium and homeowners associations are governed by 2 distinct statutes. Condominiums are under 718, and homeowners associations are under 720. And as Bill said, our law firm works hand in glove with FirstService Residential, who manages a large amount of those associations. So the reason I bring this up at the outset about the 2 different and distinct statutes is they're governed similarly, but also differently. And knowing which statute you fall under and which entity or which, whether you're in a condominium or whether you're in a homeowners association is important for your transaction. There are forms you have to use on the purchase and sale contract. The statutes will differ in certain aspects. So in jumping in, I think that it's good to help our listeners distinguish a little bit about, you know, so how do I know what type of unit this is? Is it a condominium, or does it fall within a homeowners association? And one of the key points, Bill and Elana, that I think is the first place I tell people to start is the governing documents. Those are going to be, the pretty much the Bible for the association. A little way to cheat is the deed. So if you pull a deed up from the public records and it says condominium, then for the most part, you're dealing with a condominium. Bill, I'm sure you get questions or you get inquiries and the wrong reference is used from time to time, correct?
Absolutely, Scott. We hear that all the time, and the general term is HOA.
Yeah.
The HOA has this and the HOA requires that. And for us, we go, we get a little anxiety there. It's because, as you stated, two completely different statutes, two completely different structures to the organization. So it's definitely important to understand for your transaction upfront. If you're a listing agent, get those documents right away and all of the requirements from the association. Understand which type of association. It's also great to help guide your client, your buyer, your seller. And if you're representing on the buyer side, exact same thing. Work with the selling agent, certainly, to get all that information as soon as possible if you're thinking about placing an offer on a specific piece of real estate. So they are two distinct. And I've also seen forms go back and forth and get confused. I've seen 720 forms submitted for a condo and vice versa. All of that will just slow down and create confusion when you get to the closing table. So it's so important to dot those I's and cross those T's and know precisely what you're working with up front in the transaction as early as possible.
Bill, you said something really important and the connection cut out just slightly, but I also want to reiterate that if you're a listing agent taking a listing in an association of any kind, it is really incumbent upon you to have a full set of the documents, which includes all of amendments to the documents, the bylaws, the rules and regulations, and the financial statements, and how a buyer should apply, who they should contact, know a little bit about the application process, the costs, and we'll get into some of those too. But I'm sure you see this where a prepared real estate agent can make or break a transaction because they are weeks ahead of the timeline. They have all those documents. They can email them the minute they have a contract. And instead of, now you have a contract and you've got some deadlines looming, and you don't have the documents in hand. So that could be problematic. And Bill, you mentioned that. I think that's a key point as a listing agent and to know as a buyer's agent as well.
That's absolutely correct, Scott. Just to expand on that, what we're seeing buyers and associations in general more savvy and smarter today than ever before. And so really, specifically having that financial statement and being able to understand whether the association collects reserves today or not, or has reserves in a fund account or not. Your buyers are going to have those questions up front. I can tell you we see it more and more today. So as soon as you start that transaction, you can be so much more efficient. You mentioned the financial statement, absolutely. All governing documents, and don't forget the rules and regulations. They can be updated from time to time by the board. So that's important to have those up to date as well. Have the entire package ready to go. A lot of potential owners or renters are going to ask those questions, and they're going to want to understand more about the lifestyle, but also the business side. What are the financial ramifications to live in this community?
And especially if the buyer's obtaining a loan, that's super important as well. So if the listing agent is prepared to address the reserves question, that's a big one as well.
Yeah, absolutely. In our chat room, we had one of our listeners, Michael, ask, what about the property use code on the tax rolls? So to determine what the property is, whether it's condominium or another type of association, and that could work as well. So I think that that's a wise comment by Michael. You know, one thing that's interesting in a condominium, you've got, and our law firm and Elana works very closely with one of the attorneys that handles a lot of formations of associations, represents developers from the ground up in setting up a condominium, from the acquisition of the land all the way through to the declaration and then the end unit sales. So in a condominium, you've got a piece of land. It's divided into units and common elements. The condominium unit owner owns his or her unit and an undivided share of the common elements, which are shared portions of the condominium. Common elements, for example, pool, elevators, hallways. So there's a distinction which is interesting. In the homeowners association, owners own parcels or lots and the improvements thereon. There are no common elements, but there are common areas. So that's you know, just a little term of art that, you know, when you're speaking about common areas in a 720 association, which is a homeowners association rather than a condominium association, you're talking about common areas versus common elements. So the homeowners association usually owns the common areas, and the owners have rights to use them in a 720 association. And I know this because I handle a lot of representation of developers who develop their properties and they set up homeowners associations rather than the condominium associations. And always at the end, at the turnover, we are issuing a deed to the association from the developer for any property that is considered common property or common area. And how do you know what that is? I typically find that in the plat. Any area that is dedicated or reserved to the association, because it's dedicated in the plat to the association, we're also saying that, okay, we're going to now deed our interest in that property to the association. So that's another distinction, and just a little tidbit as well. So getting on to some real meat here. We're going to talk a little bit about approval of buyers and how the 718, and when I say 718, I want to make sure people, when I mention 718, I'm talking condo. When I mention 720, I'm talking about a homeowners association. So a 17 versus a 720 as it relates to application fees and Estoppel fees and requests. So Bill, we get a lot of questions on application fees. You know, my buyer is buying in this association and they have to apply, and look at this fee. Is this legal? So, you know, I know that you're on the receiving end of the fees as a management company, but yes, it is legal. And yes, there is an application fee, which has a ceiling. It's $100, and I believe it's going up, but that's in a condominium association, correct, Bill?
That's absolutely correct. Yes, and there's a couple different fees to keep an eye out for. When we speak about getting the information, so for example, with us and with most reputable management companies, we want everything to be as efficient and as quick as possible for everybody. So you can simply go to our website and order a full set of documents, rules, regulations, and Estoppel, a condo questionnaire, frequently asked Q&As. Now, those are fees charged by us, the management company. Then you also have an approval process through the association. So a clear key distinction there, the management company or the property manager, even if the community is self-managed, is not authorized to approve or deny any buyer or renter in a community. that must be handled by the board of directors of that community. And that's why it's important to get that information early. So what is the fee to the association? It's a typical processing fee. It's going to cover costs of the association, such as international background checks. Perhaps there's a credit check involved as well, and just processing of the information. Know what that fee is as well. That's a second fee. So the fees can add up.
Yeah.
And then the other key thing is to know, so understanding that timeline as well with the fees. The information, I promise you, will not come instantly. Whether you're requesting documents through the management office or online, or through our care center, you can call that 24/7 as well if we manage a community and get all the information as well. But there is a time lag there. And when you pay the fee to the association, they're also going to make sure that the check clears the bank, unless they use a good system like we recommend online, which is everything's through a credit card. You can do it very quickly. And then they're going to run that through the process as well. So it will take time for the background checks and the credit checks to come back, and it will take some time for everyone to review the information. So again, it's all about being proactive and understanding that up front.
Yeah. And you make a really good point. And I go back to the original point we made about the being a proactive real estate agent. You know, it's not only in getting that listing or finding that buyer, the home, and getting under contract. It's knowing these aspects and how to navigate through this association's approval process. And be armed with the information that you need as an agent, just as if you were buying in that community, how much the application costs, how long the process is going to take, who to talk to for questions, where is the information that most people ask. You know, there's usually a list of standard, you know, frequently asked questions. I remember when I purchased a townhome in December, Elana, it was incredible. I needed to provide more information to the association than I actually did to my lender, because they asked for tax returns, they asked for bank statements, and they asked for all the typical stuff my lender asked, and then they asked for photos of my dogs.
Yeah, I got that too. I had to provide that for the condo that I bought.
The photos of the dogs, they wanted to know dog names, dog weights, you know, so
yeah,
that's
the vet record, make sure they have all their immunizations.
Correct. That's right. Yeah. So, you know, that's an interesting aspect, because so often I deal with frustrated buyers or frustrated sellers who, you know, are just kind of engulfed by the process. And there is no better way to get through a process than through knowing what the process is and educating yourself on how to go through it. And this, you know, much like FirstService, and it actually might have been FirstService that handled this association, Bill. The process was very, very user-friendly online. The application process, I uploaded documents, and you know, it told me when I was done or what I was pending, right? So, you know, it just, I would encourage every agent to know exactly how that process works to expedite for their seller or their buyer. Back to costs, you know, we talked about application fees. The condominium association can require a transfer fee or application fee. Those terms are interchangeable, not to exceed $100 per applicant. Husband and wife is considered one applicant, or one couple is one applicant. This is going, there's a Senate bill that I believe is circulating around for, which will go into law, Senate Bill 630. And that fee is going to increase now from 100 to 150. HOAs, on the other hand, they do not prohibit, limit, restrict fees for application or transfer fee. So I believe that that's one distinction that we can talk about when we're talking about application fees. you mentioned the word, and so often if somebody's practicing in a certain area, they use words, jargon, acronyms that they're used to. I've spoken with guys and gals that work in the government, and they are big on the acronyms. So when we talk about Estoppel fees, that's a word that could scare people, like, what is this Estoppel fee? Or what is this Estoppel? Well, it's a fancy word for it's information, and it's the word Estoppel is the person or the provider of that information has to give that information and is thereby stopped from saying that it's any different within a certain period of time. So that information that they give out is good for, it's represented certainly, and it's somewhat warranted for, let's say 30 days. And they're stopped, just like a bank would be stopped from changing that and saying, oh, no, I made a mistake, and here's a new number, when everybody else relied on that and that document. So let's talk a little bit about Estoppel fees and response times. I think there's some similarities, Bill. Condominium Estoppel fee amounts. I want to say that, or condominium Estoppel timing. And usually the title company will request the Estoppel letter, and that is a 10 business day turnaround requirement by statute, correct?
Yes, that's absolutely correct.
Okay. All right. And if there are Estoppel fee is capped at $250 pursuant to Stat 718. If there are no delinquent fees owed. So if there are some delinquent fees, then there can be some additional charges. So a buyer that's making an application in a condominium, you've got on the application or transfer fee side, the buyer might have to pay for that. Typically, the Estoppel fees are contractually governed, right, Elana? And the seller would be required to pay for Estoppels. Am I right on that, or am I wrong?
Seller typically pays for the Estoppel, yes.
Seller pays for Estoppels, yeah. So there you kind of see a little bit of an even split. So we've got a $250 more or less fee for Estoppels. We've got a 10 business day turnaround, and that is the same in both condominium and homeowners associations. So that's the fees for the fees and the timing for Estoppels. Another question we get a lot, Bill, is buyer approval. As a title attorney and a title company manager, along with Elana, we often are waiting on a buyer's approval for the association. And those are not statutorily governed, right? Those are basically pursuant to the declaration. So, yeah.
Right. So understanding that turnaround process for your buyers and sellers is also critically important. Again, it's about setting the expectations and being proactive so that you don't jeopardize the deal at the 11th hour. Understanding how that process works, as I mentioned before, if you complete all the paperwork correctly, that's always important, and everything is submitted completely, and the fees are paid to the association. Again, the management company has no authority, or the property manager has no authority to approve or deny. It has to be reviewed and ultimately approved or denied by the association, which is the board of directors and or a screening committee.
Mm-hmm.
So you're looking at perhaps two groups of folks in each association that may review this information before you receive your final approval. Right. Typically what I see here is around 30 days, typically, a board and or a screening committee will set a regular monthly cadence, a regular monthly meeting to review all of the packages for that month. And so knowing that up front is critically important. You don't want to find yourself in a situation where you're closing in 2 weeks and they just had their screening process meeting and all the approvals went out, but yours wasn't included. That could delay the closing. That can be a real headache for everybody. So the questions to ask. You should receive that screening package, and typically it has you ask the question of the manager or the management company, what is the timing for the turnaround? When do the committees meet to do the approvals? How can I expect to receive that information? Absolutely, you have the right to know all of this information, and it's better to know that up front early before you get deep into a transaction.
That's a fantastic point. So if I'm a listing agent and I'm taking a listing in an association, I want to check with that management company and find out exactly what you just said, which how do approvals happen? Is it done on a monthly basis? Is it done every 2 weeks? When do they meet? Is it done through a screening committee? Does my buyer, does he have to go to an interview? Does he have to be present via Zoom? These are great questions. Then there's no wrong question, and education is really what, educating yourself as an agent into what the requirements of that community are is paramount in helping facilitate the transaction go smoothly.
And Scott, another key question. I'm sorry, Elana, to cut you off there, but think about your clients as well, right? If you're having these educated conversations with your clients up front, they're going to have a perception, and I've seen this. They may not appreciate that process. They may not want to have the experience with an association such as this. If it's stricter on pet rules, for example, or there are a lot of processes and procedures. Other clients may really appreciate that. They like the extra checks and balances, the extra security, the extra processes. That's the type of community, it's about lifestyle that they want to live in. So understanding that about your client as well, you're doing them an excellent service by walking through and educating them on the process.
Right. And especially right now with COVID, Bill, I think you were telling us yesterday that a lot of the meetings now are on Zoom. So depending on the association, that could be, I guess, good or bad. That could be more expedited or more delayed. What are you seeing on your end? Do you see that it's helping expedite, or is it delaying approvals?
It's an excellent question. I will say that mostly it's a change in process and a change in doing business. So many real estate practitioners out there that we've worked with over the years, they're used to coming downstairs and going into the office to check with a manager. Hey, how's my package doing today? You said it was next Friday, just checking in. Certainly that's hard to do these days. And I mean, you may have to make an appointment, but most everything is definitely going to be online, and most information and the meetings conducted by the board and the association are also going to be online to respect all of the CDC guidelines, right? So it has changed everything. And then it goes a step further. It has changed the move-in process into a community. So if it's a condo and it's a high rise and you need to reserve an elevator, we again, with social distancing, we might only be able to do 1 or 2 move-ins per day in an association, and they can't overlap. So once you get to closing, you then have the move-in process. But back to the approval process again. Your client may be asked to attend a Zoom meeting just like this as an online interview and to answer questions. So it won't be necessarily in person as well. So it's changed how we've done business. And by the way, I don't think it's going to go away now. I think this is more efficiently. Everybody loves efficiency. They're absolutely going to stay around. And I think you're going to see more meetings just like this and more interviews just like this moving forward.
It's interesting. I get a lot of questions, Bill and Elana, on what an association can ask for when it comes to approving an individual buyer. So we had some we had some questions that were sent in before the actual this actual webinar, and both, when one of the questions was, can credit be pulled, or credit criteria be used, and income criteria be used, and the answer is both condominiums and homeowners associations may put into their declaration, their governing docs, that certain income and credit criteria are a prerequisite to purchasing a unit and or a home in that community, and that approval or denial can be rendered based on that criteria. So and then we got another question which I found was interesting. A buyer with a disability, would they also be susceptible to the same credit and income verifications? And you can't discriminate based on disability, but you can treat everybody has to be treated equally. So the income and credit requirements for somebody disabled would be the same as income and credit requirements for a non-disabled individual. And this, because there has to be equal treatment across the board for all owners. So those were two questions that came in, and I found those to be interesting, and I wanted to mention them. So turning to some best practices for agents, I think a lot of times things that hang or slow a process down in the lending realm is litigation. So Bill, is there a way that a realtor can find out, and reserves, so reserves and litigation? So I think we touched on some of the reserve discussion, but an agent wants to find out about litigation in advance or reserves. I think that's important, right, Bill?
Yes, absolutely. And the best frequently asked Q&A documents I've seen, that's a standard question. Is there any pending ongoing litigation? The best ones I've seen, they check a yes box or a no box. The yes box in a great package will automatically have a summary from the association's counsel attached to it about that litigation. The underwriters are going to want to see that, and certainly your buyers may be interested to know as well. What does that matter? But look for that. That's a great little tip there. If you see yes, check that there is litigation and there's no supporting documentation, know for sure that's going to be requested. So ask for it right away. Ask for it up front. If it's not already there, just go ahead and ask for it. It will absolutely be requested. I've seen that slow down the process. The reserves is the same type of process. Are reserves collected? Yes or no? If so, how much? One key number to know is 10%. Most lenders and underwriters and federally insured mortgages, if your client's getting a mortgage, require at least a 10% annual contribution to reserves. That's 10% of the total operating budget. You can look at that if you get that financial statement up front as well. Do the quick math, understand that that's there. That should tie to the frequently asked Q&A as well. So those are two key things to look at. You'll also notice that information in the Estoppel package. So you'll see a breakdown typically of what are the maintenance fees. Are they paid per month, per quarter, annually? Everything's got to be supported by the documents. And are there any delinquencies, or are there any special assessments? So those are key things to know. The banks are not going to be too excited if they see some delinquents, if they see a bounce on the account, if they see some unpaid special assessments. And that's not all bad either, because obviously you want to make sure for your client that the account is brought forward. And that special assessment, if there's anything outstanding or pending, that could be a great point of negotiation between the buyer and the seller as well. It's great to take care of that and clear title up front.
Sure.
So those are the key things I would look for in those two pieces.
That's great advice, and I'm glad you actually touched on special assessments. So in community associations or HOAs, the Condominium Homeowners Association, we have regular assessments or assessments, which are your monthly dues. And then we have special assessments that are levied by the board based on a need. So if they're, for instance, in a condominium, let's say they need to repaint the entire building, or they want to resurface the parking garage or parking lot, or they want to fix all of the salt pitted railings because this is an ocean, seaside condominium, they will likely special assess those, all of the units equally. And that's a very important aspect to know about as a listing agent. You want to know whether or not there are any pending special assessments. You even want to know, because and Elana knows this really well, is because our contract, the FAR bar contract, which most people or most agents are using, there's language in that contract which not only says that there's been a levied assessment, but there has been a pending assessment, which equates to an assessment that has been discussed in the minutes over the last 12 months. So, if I'm a listing agent, I want to know if anything is going to be rendered at some point, if they've talked about it. Because why? Because my seller will have to disclose that. And if they don't, and they just happen to so levy that, then we've got an issue, and where the seller would have to pay for the entire special assessment, rather than arming yourself with the information up front, knowing that there is something coming down, but my seller is going to be out of this unit by the time that this actually goes into effect, even though the assessment might be levied and the money portion is decided and agreed upon, then it's really going to be the benefit of the buyer. So you want to make that a contractual issue, shift that responsibility to a buyer who's going to benefit from the new railings, the new paint, the new paving, and move on that way. You don't want to get caught with your buyer or seller inheriting a special assessment that they did not expect. Correct?
This is in the condo rider.
Yeah. Yeah.
And as such a key point, every single time, if that special assessment isn't disclosed, your transaction gets done, closing's done, everybody moves in, they're happy. And the next thing you know, they get in the mail the special assessment documentation. The first thing those buyers do, if they know with their counsel, is they request through us, and they're entitled to all the records, the last 12 months of meeting minutes documentation. That's the first thing they do. So do yourselves a favor for sure, have that cleared up and nailed down, triple confirm it up front. It will come back, I promise you, in this market. So we've seen that a lot. It's a great point to raise.
Yeah, and I want to reiterate this because it's so important. So there's the Estoppel letter, which will be paid for and will go out and will come. And usually it will say, are there any special assessments that are levied? And, if one has not been voted on and ruled into effect, it's not been levied. So the answer is no. But what Bill is referring to is also part of our purchase contract in a condominium association, right, Elana? Where if it's discussed over the past 12 months in the board meetings, it's in the minutes, then it is pending for the purposes of the legal contract. And that's why Bill is saying that the first thing they do is request the minutes, because these things aren't cheap. And some of them, $10, $20, $50,000 paid over, a period of time. But, it all of a sudden takes your unit from, you have your monthly calibrated payment of X, and now it's X plus, and you didn't anticipate that. So I think that's a very important point. I wanted to reiterate it. Elana, anything on that? You've seen this stuff too.
Yeah, just want to add, there's ways that we can handle it. whether we are handling through the title company or the law firm, we can hold an amount in escrow if the amount hasn't been decided yet, and the parties negotiated that the seller would pay, for instance. So there's different ways that we can go about it, even if the special assessment was discussed, but the exact amount wasn't agreed to yet.
Okay, so Cynthia out in Cyberland asked a question, and it's a good question. I'm going to mention it. It's what if a CDD is also in the community? When do they come into play with special assessments? A CDD is a community development district, and I like to think of these things in two different buckets, Cynthia. Really, we have the assessments that are levied by the association, and then we've got community development districts or special taxing districts that have everything to do with the municipality themselves. So for instance, and I'm going to speak to more of a special taxing district. If a municipality wanted to, say, repave roads or put in new lighting, they might assess through a non-ad valorem tax, a special assessment that goes on the tax bill for those homeowners in that area that are going to benefit from the new lighting or the new street signs or something along those lines, or the new paving. So that's a municipal government related assessment versus a homeowners association or condominium association assessment. Two different things, two different buckets, and they come into play, or you would find those out based on looking at tax rolls, and that's the main vehicle that they would show up in. And we're working right now on the FAR contract to try to clarify obligations for disclosure of sellers of these various items. And it's not easy because a lot of sellers don't know. They pay a tax bill, they see a tax bill, they pay it. And in there could be special taxing district assessments. There could be, other non-ad valorem assessments, could be a community development district assessment. So Cynthia's question was a good one.
It comes into play. I was just talking with a client about it this morning. Lines 183 and 185 of the contract. It says special assessment is the heading. So if neither box is checked, then the seller is only responsible for paying the assessments due prior to closing, and the buyer takes over the rest of the assessments for that, whether it's lighting or for that specific assessment. And
Sure.
The other box is the seller pays the assessment in full prior to closing. So want to pay attention to those as well in the contract.
Definitely. We have a lot of real estate agents that will check those boxes in the municipal assessment area as if it is the condominium or the homeowners association, and it is not. That is a completely separate function. Michael asked, are those CDD areas similar to opportunity zones? And opportunity zones a whole different topic, and not necessarily no. The answer is no, that those are two different things. But just to make sure I answered Michael's question, two different things. So best practices. Realtors want to find out about reserves, find out about litigation, get the frequently asked questions for Q&A form, get all of the condominium or homeowners association declaration documents up front, know how to apply, know the phone numbers or websites to apply for. I mean, this is a lifestyle. This is your business as an agent, as a real estate agent. So you want to make this as seamless as possible and give your transaction the best chance of going through without a hitch. So I don't know. I think, what's interesting is I get on these topics. I do a lot of talking, guests do a lot of talking, and before we know it, we're at 50 minutes and 45, 50 minutes, that's my attention span, or it exceeds it. So without any further ado, I think we've answered some of the questions that came in online. And let's see, our standardized key. Adam's asking questions about new construction versus resale. Are there any standardized key differences in the application process and or different documents required or needed one versus the other? Okay, very good question, because what you have in new construction, you're buying from a developer, and the developer is the association until turnover. So developers want to sell their units or their homes, and there is not a cumbersome application process from the developer. If you've passed the application process and entered into your contract, which is usually several years or a year and a half before the development is actually built, you've put your money down, that's in a sense, they vetted you and your money is good here. You've paid your deposits, so ergo, we're going to let you buy. There's typically not a large amount of screening that we see when we're now a homeowners association or condominium association that has been turned over to the unit owners, and now they're going to govern themselves like a committee, and they're going to put these rules into effect. So Adam, I hope I answered your question there. That was another very good question. The distinction is much easier if you're buying from a developer. You're paying the money. You're pretty much if you're able to pay the money, you're pretty much able to get through, and the application processes start once the association's turned over.
And the documents will most likely be different as well. I mean, a lot of experienced developers, especially if it's a condo project or a large HOA development, the developer is going to have their own standard contract and standard documents as well. So could be a totally different animal.
Yeah. Anything else going out, Bill, that you want to pick up before we sign off?
Just two additional thoughts on that. The development conversation, absolutely. So understanding in a developer situation, they're financially incented to sell units. It's interesting. It's the exact.
Bill froze right at the punchline. It's the exact. I think you were going to say it's the exact difference. Say that again, Bill.
Yeah. So the developer is financially incented, right, to sell the units.
Right.
So it's a lot more efficient. In a turned over association, remember the process is being administered and approved by a board of volunteers.
Mm-hmm.
They're not paid to do that job. They're serving their community. So understanding that, I think the other key component I would add is if it's the first deal you're doing in an association, just have patience with yourself. It's going to be a lot more upfront work and legwork. And then when you do 2 or 3 deals in the exact same association, you'll see that, and it'll be like riding a bike.
Great advice.
Give yourself some time and have patience with yourself and do the work up front, and everyone will benefit from that.
I love it. So let me just thank you again, Bill, for joining us and for imparting your wisdom. Elana, always a pleasure. All right. We haven't seen each other live for over a year.
I know.
Soon. All right. And to those out there that joined, thank you guys all so much. Thank you all for joining, and goodbye.
Bye, everyone.